Welcome to Transition Plans. I'm Bill Stalter, and in this webinar, we're going to talk about the aging parent and how a durable financial power of attorney can help extend their independence.
The aging parent is a topic that comes up frequently during client meetings. With the gradual decline in cognitive abilities, it is natural for parents to forget to pay bills and to miss important deadlines. And failing eyesight or hearing may also play a factor. And while COVID is no longer as dangerous as it was in 2020, elderly Americans remain the most vulnerable. Most will survive, but seniors are more likely to suffer from brain fog. Cognitive abilities may be impaired for months or longer, and symptoms are very similar to Alzheimer's. Clients frequently inquire about powers of attorney for the parent that needs a little assistance maintaining their independence. Clients describe how the parent has become susceptible to scams, and the parent may be more compulsive when watching advertisements on television. In some situations, it's taken years to discover the parent has mismanaged their resources. And in worst case scenarios, the parent ends up in financial ruin and can no longer afford to live at home. A durable financial power of attorney can serve as a safeguard against imprudent transactions by the parent. With a POA, the agent can monitor bank accounts, credit cards, and challenge fraudulent activity. And when caught early, the agent can also reverse transactions that are just imprudent. While a parent may be reluctant to share control over their finances, the financial power of attorney can be used to extend their independence. Signs that a financial power of attorney might be needed for a parent. Mail is often pushed aside or thrown away without being opened, and bills for utilities, medicine, and taxes go unpaid. The parent is confused about taxes and the need to file a return. Or the parent could be confused about Medicare options and frequently asks for help. I've also seen where the parent asks the same question frequently, and the individual becomes defensive when reminded of that fact. I also look for when deadlines are frequently missed, or tasks are completed but then forgotten and repeated again. Or watch for the parent who has difficulty with decisions about records that should be retained or destroyed. And again, vision or hearing that deteriorates to the point that they can no longer confidently read financial documents or negotiate telephone transactions. After a financial power of attorney is in place, I would recommend the following proactive steps to further protect the parent. Obtain username and passwords for the parent's online accounts and check their current status. Review 1 year of statements from banks and credit card companies looking for fraudulent or questionable transactions. Request a statement from the mortgage company and see whether payments are current. Contact life insurance companies for a current policy statement. Has the parent made any loans against the policy? Are the premium payments current? Then begin monitoring the mail for bills. And put necessary expenses like utilities, rent, mortgage, and insurance on autopay. I recommend to clients that they be especially proactive with the banks and financial institutions that the parent uses. Financial institutions often create their own required power of attorney forms that require additional protections for the bank. And a bank does not hesitate to reject a valid power of attorney in favor of their own form. But when a bank rejects a power of attorney after the principal has lost capacity, the family will be forced to open a conservatorship. So, to avoid this situation, I recommend that the clients take the power of attorney form in while the parent still has capacity and give the bank an ultimatum. Accept this form or I'll take my account elsewhere. On our compliance blog, I have an article titled The Powerless Power of Attorney. It's about a New York Times article describing how many people were frustrated when they attempted to take their parents' power of attorney into the bank. The bank rejected it. To avoid this situation, take the power of attorney into the bank while your parent still has capacity. The bank is more likely to accept the power of attorney if it's forced with the prospect of losing the account. If you have questions this video did not answer, you may want to visit the Transitions Plan YouTube channel for additional videos. We also post on the Pre-Need Resource Company Facebook page and to our Death Care Compliance blog at www.deathcarelaw.com. If you want to learn more about transition plans, you might want to visit www.stalterlegal.com and click the Transition Plan tab at the top of our website. If you participate in a planning seminar sponsored by one of our affiliated hosts, we will discount the cost of your Essential Life contracts. Please contact that sponsor host for more information about pricing and our next Zoom meeting where we'll answer questions.